Very good. So I'm very happy today to introduce Jean-Marc Delton as the expert researcher who will talk today about a very important topic, which I'm sorry, I have to cut. Yeah, this is the echo. Sorry, I had left the YouTube with the delay. So, so welcome back to all the audience. Today I will speak in English like Jean-Marc. Sejam bem-vindos de volta no ciclo de seminários sobre IA, artes e criatividade. Today there will be a seminar by an expert in the question of copyrights, direitos autorais e autoria, in music, but not only music, and of course the issue of authorship and copyrights in with the current progress and future progress of AI based and techniques that we are talking about since the starting of the cycle of seminar. So Jean-Marc is a professor at the Center for the Study of Intellectual Property in Strasbourg University, and it's also important to mention that he has been for more than 15 years expert in charge of the intellectual property for the European Bureau, actually, office. So he has not only academic experience, but also a very technical and expertise about intellectual property for all Europe. And also Jean-Marc is also an artist. He did the Beaux-Arts, that is the school of arts in architecture and art in Paris, and he's interested in illustration, especially gravure. I don't know how to say gravure, but anyway. So he's also which led him to be interested in this issue of copyrights, authorship, and art. So without more time, I let Jean-Marc to start, and thank you again for your talk today, for your seminar. And so we'll meet at the end of the talk and for time for questions and comments. Thank you.
All right, excellent, Jean-Pierre. It's really great to be here tonight. I appreciate the introduction. It's a bit of a mix indeed. I am a bit of an hybrid, to be honest, because I used to be a scientist early on. I did some theoretical physics first. That's my first life. A bit of arts also, and then AI all the way. So I was responsible for AI in a couple of companies, and then I joined the European Patent Office, and then I learned law. And then I'm a lawyer now. So it seems a bit like a mashup of many different facets, but they all converge back to the topic we're going to talk about tonight, which relates to art, one facet of my life, if you will, artificial intelligence, and now copyright. So a bit of an interesting combination you've probably been confronted with in all your experiences. I understand it's a varied audience tonight. And we're going to try and dab in a sort of hopefully an interactive fashion. We'll leave some room for questions at the end into some of the actual, and you see not so novel as well, topics related to this broad question. So let's start. And indeed, art has been in the news. Art and AI have been in the news in the recent years. Some topics you've maybe seen, or some highlights you've seen in the past, for example, Edmond de Bellamy. We'll come back to Edmond de Bellamy at the end of the talk. And another, I would say, example provided in the news, the next Rembrandt. I'll come back to this example a bit later to show that there is a bit of AI washing. So some type of exaggeration where you want to display your prowesses in terms of producing art related to AI. But if you dig a little bit deeper in the reality of that, in a sense, algorithmic pipeline, you realize that there are many humans in the loop. And in both cases here on the left-hand side with Edmond de Bellamy, but also in particular in the next Rembrandt, where I think there's very, very, very little AI indeed, you see that the reality is a little bit more human-based and not so much algorithmic or AI-generated. There's plenty of humans in the loop. So these two examples were already quite old, actually. In view of the speed of the evolution of the AI timeline, I would say, but it's accelerating somewhat in the past years. Recent cases, actually, in the past few years, relate to, for example, Zarya of the Dawn. I will come back to that also later. It's a comics, and again, it's been put to the test to the US, United States Copyright Office, to decide whether or not there was sufficient originality, human input to claim copyright protection for this work. So indeed, it's a new trend at the moment. You've been confronted, probably all of you, with Stable Diffusion, Midjourney, DALL-E, and so forth. And indeed, we can create very easily work that pass for human created. I mean, that look like they could have been created by human beings, like this one, for example, that in a sense would require some level of skills in terms of graphics to be able to produce if you wanted to create a comics, for example. So that's one example indeed where Zarya of the Dawn actually raises some issues and confronted, in a sense, the offices, the administration, to the threshold of what can be copyrighted and what cannot be copyrighted. Another example, quite recent indeed, is by another character, another person. This one is if I can just move my slide, yes, by Stephen Thaler. Stephen Thaler has a very long and interesting history in the field of AI-generated artifacts, not only in art, but also in patents, actually. So, but I won't talk much about his particular endeavors in the field of patents and technical creations. But here again, Stephen Thaler has tried to push the boundaries of what is considered machine-generated, and is claiming indeed, and we'll see the case later, that this work, a recent entrance to paradise, was produced by his created machine. It's a neural network of some kind, particular architecture, that is capable of producing images, a bit like Midjourney. But in this case, Stephen Thaler claims the machine did it on its own, without any input from any human being, including himself. And for that reason, he attempted to put the name of the machine on the title, basically on the work. So the artist was not Stephen Thaler, but the creativity machine. So that again was a question asked to be answered by the US patent, the US Copyright Office, sorry, and we'll see the answer a bit later. So this is quite recent use from the past years. Prior to that, in the field of music, there've been quite a lot of work, and you'll see, I'll come back to the history in a second. Probably you've seen that in the past talks, but I very briefly just outline a sort of a broader history of algorithmic creativity. Those are works created by teams related to Jean-Pierre, actually. François Pachet and Benoît Carré created that piece of music, Daily Scars, inspired by the Beatles. And we'll see a bit later also, I'm teasing you here, that that notion of inspiration becomes quintessential, very important in the current trend about AI-generated art. Here again, we can see, okay, that's a production that's inspired by existing music, and of course, you know that by now that AI today is machine learning mostly, not only, but essentially machine learning. And to learn those new artifacts, essentially you need to draw some correlations, some basic notions from prior works. So in a sense here, the Beatles were the source of the inspiration, but the source of the data also that was digested by the algorithm in order to help produce this work. Humans were very much involved in the work, as in the case of I Am AI by Taryn Southern, also a work claimed to be produced by AI. But again, if you look a bit more carefully, the production of the human being is very much important. So we have to be a bit careful in putting the right level of threshold in what's been done by the machine and what's been done by the human beings. In fact, we'll see that in most of the cases, if not all cases at the moment, there's a sort of a conjunction, an articulation, a hinging between those two worlds, the machine world, algorithmic world, the data world, and the human contribution. But again, as I said, the algorithmic relationship with creation is quite old. I mean, you see here a very old piece of book. Actually, it's a book that dates back from the 1787 in a particular journal of I think Journal of Luxury and Fashion, and it was referring to a game invented by Mozart in order to produce automatically some music in an algorithmic, in a sense, fashion. So there's actually been more recent emanation of that particular rule-based music generation. Here you see one based with very very 80s or 90s style of graphics, but indeed based on this rule, you can produce very easily some pieces of music that, I mean, seems actually reasonably interesting, if not slightly predictable, but that's part of the interest. I mean, you get something in the sense that you put inside the rules in order to produce an object that seems interesting. In the 20th century, in the fields of graphic arts, it's been very, very common and actually very closely related to the advent of the computer. Just after, in the 50s, actually, works were being attempted to join actually this rule-based algorithmic production of artworks and the field of graphics. For example, here you have Frieder Nacke is actually a very, very famous artist from that period, very early on attempted to play actually with those rules and to try and invent new patterns in a way that could be automatically generated at scale with large numbers. And again, that's very important today, the size of the production, the quantity that can be produced by a machine with respect to the one that can be produced by human beings. We need to eat, we need to sleep, we need to have limited amount of cognitive capacity in the day. For machines, well, they can work much faster, of course. That notion of scale is actually very, very important today. So we see it happening in the past century already, and this notion also of algorithmic art, where you have a bit of rule-based settings that sort of give some power to the creator to try to sort of inject his own perspective on the work, but also some level of stochasticity, some randomness, if you will. And the combination creates those interesting patterns. You have behind these patterns maybe a code, a piece of code that is an example of a code here that you could imagine controlling some of the rules, but you add some unpredictable character, if you will, inside this sort of framework of this rule-based framework that enable to inject some kind of novelty in the output. Do you as an artist control the output? That's a bit of the question we need to ask ourselves also today. What is the level of anticipation of the final work that is required for an artist to be, in a sense, qualified as an artist? What's the relationship between this intention, the original rules, for example, you create, and the capacity to control the output? Those are very, very important questions when you click on a button and you generate an artwork. Think Midjourney, think Stable Diffusion. How much control do you have on the output? Some, maybe, in the case of those applications, you control the prompt, for example. You control the text that's going to be injected in the system, but you don't control all the parameters that are producing eventually the image. So there's a bit of a gap, I would say, between this world of rule-based algorithmics production and this next Rembrandt. And you see the paradox, if you will. On the one hand side, you have something that's automatically generated with randomness, and that's quite interesting, I would say, artistically. Why not? Claiming that indeed there is an element of human-based input on the left-hand side of the image, if you will. On the other side, we claim there is AI, but sometimes there is not AI. So we have to be a bit careful, and we'll try to dig deeper tonight in this question. So other issues related to what's happening today in the field of AI and art production, as I mentioned a second ago, are related to scale. Some oldish already example, but it shows actually that it's been there for a while in the field of music. Some tools have been created in the past, I would say 10 years, that allow artists to generate music, not necessarily the next hit song, but maybe jingles, for example, at lower cost and at scale. And those are just some examples, pretty much random. What's interesting, and it used to be, it's a company called JukeDeck, doesn't exist anymore. It's been bought by ByteDance. ByteDance is a company that owns actually TikTok. I don't think that the amount is disclosed, but probably quite a lot of millions of dollars. But JukeDeck was a company in Cambridge, in the UK, focusing on producing, in a sense, small snippets of music. And the advertising of the company was saying that while a musician can cost as much as a few hundred to a couple of $1,000s for a jingle, an AI-composed jingle from JukeDeck, a particular company, would only cost you something like $22. So indeed, the argument in that case that justifies moving from human artists to AI-generated or partially generated works actually is a matter of cost. Of course, it matters for the artists. Prior to the conference, we were discussing with Jean-Pierre, and in fact, for a large amount of artists that don't make that much money, this kind of argument is very sensitive indeed. I can tell you that in France, for example, close to 30% of the revenue, 30% of the revenue of graphic artists has been lost in the past year. And the reason is not necessarily just a lack of interest in graphic arts in the market, but essentially the advent of new tools that allow editors, for example, to pick on their own the jacket of the new novel they're going to publish, or to make a poster without requiring the work of an artist. And indeed, that changes quite a lot when you're barely making a living. And many of these artists are not really very rich, they're just surviving. So 30% of something that's already quite minimal makes all the difference. As I mentioned before, it could lead you to go and look for another job, essentially, so abandoning your work as an artist. So this is a market disruption, not necessarily a theoretical, philosophical debate about what is an artist or what is copyrightable. It's just a choice given to people in the ecosystem of artistic production to go one way, the Mid-Journey way, if you will, or to call for a human input. This is happening at the moment. Okay, the world is adapting, of course, but we need to think carefully about the consequences for human beings of those new tools, indeed. And then many other consequences that are a bit more subtle, that talk a bit to more doctrinal issues in the field of law, some related, for example, to the tools that I was mentioning, but in a bit slightly different way, where here the issue is related to the nature of the work and the nature of the creative input. In a particular example of this platform, it was essentially allowing you to, like Mid-Journey does now, put an image, propose an image and choose a style and combine the two objects to finally get a sort of a mix of those two elements. The notion of style, again, is quite important today because it's very common that you ask for an image to be produced in the style of someone, of an artist you like, for example. And it doesn't mean that there is necessarily an impact on the copyright, on the ownership of the works by that artist, but there could be indeed an impact on the revenue, on the acting as a competitor in the field of the work produced by this artist. So here again, this notion of style that sort of escapes the boundary of natural protection by copyright can create also can have an impact on the life of the artists. A very practical one, and it's a bit of a joke, if you will, but it was a bot proposed many years ago already by the Deep Forger, and you see it's not hiding. His objective is about actually forging. So in that case, again, we can see that there is, of course, a direct impact. So I won't go much into the technical aspect of the AI business, of the generative AI pipeline. You've seen that elsewhere, I assume. Very simply speaking, and just to relate to what I said before, the paradigm shift in the past I would say, 20 years or so, has been a gradual move towards machine learning from something that was quite famous in the paradigm, the dominant paradigm in the 80s, 90s, which was essentially expert system, where you set out the rules, a bit like Fredrik Nack before, you give the rules and the system generates the image based on those rules. That was one way to do AI at the time. Now we do something else. We train a machine based on data, and you'll see that data is super important today in order to, in sense, infer those rules by building what we call a model, a neural network, the parameters of a neural network, and you do so by training, sometimes guiding, and all those actions I will refer to in the course of the talk can be very important to assign some level of human input that can be meaningful indeed eventually and manifest itself in the final output. So the final output is the sort of the work you want maybe to protect. So this paradigm shift can be declined in two ways. You can go from, say, pieces of art to try to generate an image. Classify, for example, an image. Is it a portrait or is it a landscape? That's one thing. But you can also essentially go the other way and ask for the machine to make a portrait, and indeed it can generate, as you know by now, an image that looks like a portrait. Those are, of course, generated by machines. And there's been a very, very fast evolution in the past years again. I mean, it's very hard to fathom for people invested in the field, either as technical people, as you've met before, or as a lawyer, economists, and so forth. We've seen sort of such a rapid landslide of technologies moving one after the other and changing always pushing the boundaries. So a few years back, for example, what we could do, it's already 10 years ago, so it seems like an infinite amount of time at the speed of the technology, but the best we could do for generating faces, and I can tell you that at the time we were finding that absolutely amazing, was that essentially small images, 128 by 128 or even smaller, and things that were looking okay, but it looks a bit like Francis Bacon. I don't know if you know this artist, but faces that are a bit distorted. It looks fine. I mean, we recognize faces there, but they're not exactly, passing as kind of real ones indeed. That could be like artistic ones, but not real faces. But very, very early after, just a few years after, those were the results already. And now this is a website called This Person Does Not Exist. Well, this person indeed does not exist, his face does not exist, and all those faces are completely imagined, if you will, or created, produced in the meanders, in the neurons of the neural network. So that creates sort of a change of paradigm also for what we mean by truth. Do we believe images like we used to in the past? How much credit do you put in those images? You've seen in the press, you've seen Donald Trump and plenty of examples, the Pope also in fancy dresses or different situations, a bit funny. But in a sense, it poses essentially deep questions about the nature of truth today, when those artifacts can be generated at a level where indeed they would pass as real, and where actually for which we don't have exactly useful practical metrics to decipher, to differentiate those that are human created or real and those are purely machine created. That's a bit of an issue. In the field of art, we've pushed again the boundary, because now actually we can generate not just images, pictures, for which we have a large basis for learning. Take the internet, for example, all the images available in the internet, but we can also translate them into works that indeed look like as if they were created by real artists, living or dead. So that's interesting. Again, you may say that seems quite actually banal by now, but that poses actually quite deep question for the legal scholar, and we'll see some of those together tonight. So just an example from an application called portraitai.app. And again, there are real people. I think you see Donald Trump, Zuckerberg on the left lower side. I don't know, there may be some others I don't recognize, but essentially they're real people translated in the art of an artist from the past century. So what are the novelty here? Novelty is actually another one related to market. And this piece of art called Edmond de Bellamy actually raised some interest in a few years back in 2018, because it was sold at Christie's for an amount of money much larger than what was anticipated before. People were hoping it would be sold for something like 17,000 euros or dollars, I don't remember, but the final price was actually close to $432,000. So imagine actually the discrepancy, and it actually was one of the first pieces of art. It was not the first piece of art that was sold at auctions, but the first one indeed that was sold at such a high price, and for which, in a sense, the spread between what was anticipated before and the final price was so large. Is this art? Can it be protected by copyright? And now things are becoming a bit more important, stringent. They go away from the remits of the purely doctrinal question. They enter the field of Christie's, where this piece was sold, markets and protection. If there is no protection, if there is no copyright for this piece, or owning it, maybe a little more losing a bit of interest or value at least. So the price issue has an impact on the reality of the question we're asking ourselves. And I'm not saying it's just a question of price, of course, but it sort of emphasizes, it suddenly gives a bit more importance to the question for some. And today, as I mentioned, now we all have access to those tools. Before that, and I'll tell you the story of that, those people behind this piece. I think it's quite interesting to see of the articulation and how it was created. I'll do that at the end. But now it's changing, is that it's not just one group of people somewhere actually in Paris, 3 engineers or 3 young people, at least one engineer working on the project and capable of producing that work. So it needed some expertise. In fact, it needed quite a lot of expertise in the field of, I would say, computer science to do so. Now it's actually very easy. You just need to be able to enter a prompt. If you enter that prompt, the creation of the universe in the style of Leonardo da Vinci, well, indeed, you can obtain something that looks quite interesting. And depending on the tool you're playing with, be it DALL-E 2 or 3, be it Journey, Stable Diffusion, well, get different results, but all with their own merit. And here again, it's a matter of scale, because if everybody can play with those tools, imagine the number of potential questions, conflicts, infringement that can happen. And indeed, that's the reaction that we saw immediately after those tools being deployed in the field, is that you could see on Twitter, or X now, some reaction from artists claiming that a new AI image generator appears to be capable of making art that looks 100% human-made. As an artist, I am extremely concerned. And you could see those tweets, there would be many examples of the same kind of tweets. Is it fair? Could those works be copyrighted again? And should we ban them? Those were questions. And should we ban them? Well, another example why that question was raised was something you may have seen already, a competition in Colorado in the US, where people could put forward their works, graphic works, and that was won by one of those AI partially generated, I would go with the artist there, who said that indeed he used those tools in order to produce his image, but also injected a lot of his own, creativity, choices, or effort in order to refine the final work. So indeed, here the boundary is not so clear. Is it purely generated by a machine, or is it just some kind of collaboration with a tool? And it's just a new tool that happens to be available to the masses, to all of us now, that enables to create things that may be competing with human beings. So the question here again, should we again ban them if it's unfair competition to human beings who would strive, would go to art school, take many years of their life trying to learn a skill, and suddenly anybody can do better, essentially by clicking, pushing a button. Is it fair? Does it matter? I mean, those questions are quite important for us. I mean, is it really something so important? And does copyright have something to say there? I mean, is it a new question, in fact? And that's something actually we can ask ourselves. And then we should, because actually it's not so new in reality. And those questions have been asked for quite a long time already. Why? Because, as you know, as artists, we use tools, and tools have been evolving with technology. So there's a sort of a coincidence of the evolution of the mechanism through which we create the processes, the artifacts, the instrument, the tools, the technologies, and the nature of the object we create. For example, photography. That's a picture taken by Napoleon Sarony in the late 19th century. It's a portrait of Oscar Wilde, a famous writer. And again, that's an interesting case because a company, Burrow Giles, actually was essentially a printer company, so for specialized in lithography, produced unauthorized copies, lithographs of this work. So the two technology competing here: lithography, which is a mechanism by which you can reproduce by printing, it's a printing process, other works, and again another object happening in the field, photography. And the debate was whether or not the photography was protected. There was an exclusive right owned by Napoleon Sarony on that photography that would allow that person to prevent this company, Burrow Giles, to, in a sense, reproduce it using a second technology, lithography. And the court, asked at the time in 1984 that question and said, okay, well, indeed, the court said, we consider there is indeed quite a lot of effort, choices in the particular characteristic of that picture. They said indeed that it's not just a mental conception. You can see choices in the posture of the character, in the framing, etc., etc. All things that seems quite obvious to us when you take a picture and you know many famous artist photographs as artists that we wouldn't be debated as artists today. Of course, at the time it was actually a new question, and the question was raised because of the advent of this new technology, photography. So even so, actually, as you see on the left-hand side, others were some famous artists, Ingres and Puvis de Chavannes, were actually signing a petition against photography as art. You see, a defensive mechanism that's not so far away from the post we saw on Twitter before. We should be concerned because this new thing is competing with our capacity to produce realistic paintings, which was a skill actually at the time that was of high value. So now, what's the consequence of that? Well, you could say the consequence is that artists disappear and everybody forget about paintings, oil paintings. We all move to photography. Is it really what happened? Well, not really. Maybe some aspects of the art went a bit, sort of diminished in interest because maybe the public considered less valuable a particular skill of making things very, very realistic. But maybe it also was a catalyst for new trends to emerge or open, a breach in the art ecosystem for a new kind of artist or new kind of art to be allowable. Think Impressionism, for example, and the later more modern forms of art. That's a question. I'm not sure it's all that simple, but you could imagine that technology has been sort of inflecting, nudging the debate about the nature of oil painting, for example. So copyright is an element in that field that has been also invented to participate in the production of new artifacts. And in fact, I want to also give you a sense of what we mean by copyright and what is it useful for. So as you saw, it was actually very much in that debate early on, in that Burrow Giles versus Sarony case in the US. And we'll see that it's happening, as I mentioned before, with other more recent cases in the field of AI. But what is copyright and what is it about? What's the purpose of that notion? In fact, you could boil it down to a very, very simple construction, a bit more complex than that, but essentially it's some legal tool that strives at encouraging, at incentivizing artistic creation, artistic productions. Of course, it's very broad as a notion so far, but it's actually the core, the gist of the matter. So it's a tool so that people, in a sense, want to produce more creative art, explore creativity in all forms. That's the idea. And the idea is important because we consider creativity. Okay, copyright is essentially focusing in the discussion we have tonight about artistic copyright, but it also touches other kind of works. It touches databases, it touches software, but the connecting tissue between all those elements is the creative element. So we want to incentivize human beings to be creative in an original fashion. In the technical sphere, it's patents, the equivalent. We reward inventors by granting them some kind of right, an exclusive right that gives them control over their invention. And in a sense, that's a mechanism by which we hope, in a sense, we will incentivize those people to invent, to create new technical artifacts. And there are other elements in the field of intellectual property that target different modes of creativity. Copyright for art is the go-to tool to incentivize and encourage artistic creation. How does it work? And essentially, it's very easy because you don't need to register your work. You can. It's for practical reason that you can, in the US in particular, register your work in front of the US Copyright Office, but it's not a requirement. It means actually that anytime you draw a scribble on your notebook and or you dab in music and you do some kind of experiment on your keyboard or any other kind of instrument, you're generating works, maybe original works, and if they are original, then they're copyrighted immediately. The simple fact of them existing, being materialized in the world, grant you copyright if those works are original. And we'll come back in a moment about that, to tackle that notion of originality. Means no registration, no fees. It doesn't cost anything to obtain the copyright. You don't need to put a little C with a circle around it on anything to materialize this copyright. It's just the originality and the fact it comes from you, the artist. So it's very easy indeed. And indeed, you can imagine that if anybody can create copyrights like so, there will be copyrights everywhere. And indeed, there are actually. So what kind of rights does it give you? We'll come back to the rights in a moment, but they're limited. It's not infinite, it's not forever. There are rights that are limited in time, but it's quite a long time, actually. It's 70 years after the death of the author. So if you have created a piece of music that is considered copyrightable because it's original, you've created it, and there's a modicum of originality there, then indeed you have a right to exclude others from doing certain things with your work for a long period of time, even after you're dead. So it's your ghost or your the rights holder, we call them, your family, for example, will be capable of enforcing those rights, but it takes a long time for those rights to disappear, 70 years after the death of the author. And in fact, there's a few exceptions. If there is a war in between, it can be extended and so forth. There are a little bit of details there, but it's quite a long time. And an important element that we need to think about, especially with this advent of AI tools, is the fact that AI protects not any form of creation, but the expression of a creation, the expression of an idea, not the idea itself. I'm thinking, for example, of a beautiful painting. It's an idea. The idea is not protected as such. The materialization of this idea is protected. So we have a sort of a spectrum between idea and expression. Of course, it's not binary. You can imagine there is a bit of fuzziness in between, but one side is not copyrightable, whereas the other can be, under condition, copyrighted. So the ideas are, free to roam. Essentially, we want to be able to share ideas by exchanging those notions freely without enforcing them, putting them in boxes and assigning rights to them, which would stifle, if you will, this sort of layer, very abstract layer of exchanging of concepts, ideas, where indeed we consider, the society consider it easier and beneficial to leave them outside of the scope of any kind of exclusive right. So this is the idea. What kind of rights are being given? Well, the economic rights. I mentioned the economy already quite a lot. It's important. And the owners have some exclusive rights. Exclusive meaning that they're owned by you and only you. You've got the right to exclude others. It's a kind of a property, if you will, on an immaterial asset, your work, and it allows you to exclude others. For example, prevent them from copying, reproducing the work, from renting them, lending it, for performing if it's a work that can be performed in public, communicating to others, and making also adaptation of that work. This is a list. There are other details there. It depends on some jurisdiction, but mostly actually this is essentially the gamut of rights that are being assigned to the authors, and those are economic rights because you can monetize each of those elements. Moral rights are very important indeed with copyright, depending also on the jurisdiction. They're not equally important in the US, for example, and in Europe, where they're slightly more important. In France, in particular, we have give a lot of importance to these moral rights, and they give another layer of control over the output, the creative output, the creative work being produced by the artists. Some two very, very simple one, but quite important. I'll give you here the Berne Convention, foundational work that defines the boundary of copyright, and it tells us that indeed this article 6bis1 tells us that independently of the author's economic rights, and even after the transfer of said rights, the author shall have the right to claim authorship of the work. It means the right of paternity, if you will, affiliation, attribution. You are the author. Nobody can claim they are the author if you are the author. This is an inalienable right. Nobody can remove you from that right, or prevent you from claiming that you are the author if indeed you are. Okay, that's very, very important, and that cannot be negotiated. It's not something that disappears if you sell your piece of work. You're still the author. It's still Leonardo da Vinci who painted Mona Lisa, and so forth. There's another right quite important that people know less about, and it's the right to prevent others from distorting, mutilating, or modifying your work. It's the right of integrity. So you can prevent others also, even if you've sold actually your work to others, you can prevent them, in principle at least, against them. You can prevent them to distort or disfigure or use your work in ways that you would consider prejudicial morally. For example, the use of particular word in a context that doesn't suit you is in a sense preventable based on this integrity part of the moral right. So it's a very powerful element that gives a sort of a very strong connection, a long-term, actually an infinite term connection between the artist and his output or her output, because now actually you can say, okay, I want this work to be used in specific context and not in others. I am the author. I have this sort of connection, that's sort of umbilical cord that connects me from to the work I've produced, because it's original, because it's part of my personality, and because of that, because it's an emanation of who I am. I don't want to be used in context where I would not feel at ease or that I consider morally unacceptable. Many cases have happened, still are happening, where indeed this is a clause that can be, or a principle that can be used to prevent works being displayed or characterized in ways that are felt prejudicial to the owner, if you will, of the reputation of the author. So two facets of a right, and that's I won't go deeper in these aspects, but we'll see later that those two facets have an impact on the way we use actually AI-generated works today. So who is the author? Okay, we've talked about the disappearance, the death of the author maybe, but indeed there is always an author if there is a work. There's something actually that's sort of almost tautological, if you will. The work is defined, the creation is defined by the presence of originality, and the presence of this originality is very often related to the nature of the personality of the author. So and you need that author. So indeed, there is no work without an author. We'll see that again later in some of the issues that have been raised in front of the courts, because indeed, in the case of AI-generated works, we look for this human being. Where is the human in the loop? And indeed, there should be a human in the loop. There must be a human in the loop if there is a copyrightable work. If there is no human in the loop, there is no copyrightable work. It's as simple as that. So it's actually a duo. Work is not like just the object itself, but it's the job object, and in a ghostly figure lurking about the human beings, there could be more than one, who sort of participating in injecting some level of their personality in that work. And so indeed, in the case, the author is defined as in relation to the work, and there's a very strong connection there. The person who creates, the person who inputs this mini modicum of originality in the work. Of course, the authors can transfer some part of their right. For example, the ownership, the economic rights can be transferred to others. You can sell your artwork, and other people can make money by selling it at a higher price. That's usually what happens. But again, under some practical, contractual, specific type of agreement, you need to put it in writing. But those are a very, very technical issue that doesn't really matter in terms of AI. An important element that I think also is worth mentioning is the fact that, as you saw actually in the definition I gave you before, copyright doesn't care a bit about the nature of the tool. Whether you use a brush, a camera, or a synthesizer and a neural network, in principle is completely indifferent to the accessibility to the copyright regime. So you can indeed use any kind of tool. There is no requirement as to the kind of object that has more importance or more value, or is deemed more, in a sense, valuable to access the rights. So the creation is made with a tool. It's not made by the tool. So the tool is pretty much like an extension of you, but you are still the person creating. And so the creation in terms of the copyright has to do with certain concepts and not with others, not with the nature of the tool. As I mentioned in a second, you don't need, as I mentioned also before, to register it. It can be, in very different forms. It's actually relevant. It could be some piece, some drawing in the sand, some pieces of music with glasses, whatever. It doesn't really matter. Actually, the expression is indifferent. The form, it has to be materialized, but the category of art you create is very open. The merit is a notion that has been debated in the past, but it's also irrelevant. If you make a very simple drawing, it's not because it's simple that you cannot be rewarded by copyright. It's not because you're Vermeer and you're making very, very complicated kind of paintings that the work has more copyrightability than if you make a blue clown. The painting all blue, for example, a single piece of uniform blue painting. One may seem more simple than the other, but it's irrelevant for copyright, okay? And the destination, the public to which it's addressed, also absolutely irrelevant. So here I mentioned in a case from an old case, actually, from the beginning of the 20th century, where it says it would be a dangerous undertaking for persons trained only in law to constitute themselves as final judges of the worth of pictorial illustrations outside of the narrowest and most obvious limits. So indeed, it tells us that if the judges were the one defining the merit, the boundaries of what's acceptable in the field of arts, something would go wrong. And indeed, because the judges don't have that single capacity of defining art, who are they, in fact, to define art? They can define proximity between two works, and we'll see that's the way we do to identify infringement. If two works are conflicting and one is claimed to be the copy of the other, infringing of some of the rights I mentioned before, for example, the reproduction rights, you made a copy of someone else's work, you try to pass it for your own or to sell it, well, that person, the original author, has a right to say, no, there is an infringement, please stop. And the judge has the capacity to measure the difference or the similarities actually between those two works. This is essentially what that judge would do, but not qualify what is characterized as art, in essence, in objective ways, and what is not characterizable as art. So it's interesting actually to see that debate also very early on, because actually it's a very actual debate. If you say it's easy to make a piece of art with an AI system, is it a good argument, or should the argument lay elsewhere than the facility, the speed at which you can produce a piece of work? But is it the real question? Probably not if we look back in time and if we follow the same guidance as in that particular cases. So this is for the negative in a sense, but what is required, I mentioned already, so I reiterate on that. To get copyright protection, you need the presence of a work and some kind of thing we call originality. And I'll give you some example. So for the work, it's actually quite simple. You need that object to be materialized or produced in the real world, not stay in the remits of your brain, if you will. For the notion of originality, I'll give you some example of in Europe essentially, but pretty much the same everywhere. We find, there's slight variation in the US, but I'll give you an example too there. So in that particular Funkemedian, for example, case, they give you essentially all the right steps to approach that notion. They say, I'm going to read it, as is clear from well-established case law, it's not the first one, in order for subject matter to be regarded as a work, which means a copyrightable work, the subject matter, the object, must be original in the sense that it is the author's own intellectual creation. That's the first step. It's your work. You've created it. It comes from you. You just haven't copied it. That's very simple. Seems obvious, but at least it has a merit of being stated. And then this decision explains us what we mean by original intellectual creation. Sorry. In order for an intellectual creation to be regarded as an author's own, it must reflect the author's personality. That's a bit what I said before, which is the case if the author was able to express his creative abilities in the production of the work by making free and creative choices. This is the nexus of the matter. This is the center of the notion of originality in Europe, essentially, and in other jurisdictions, the capacity of anchoring, of expressing in the work, and they have to be expressed in the work, free and creative choices. Of course, then the question is to be, what do we mean by free and creative choices? Free is relatively easy. Free is not, essentially purely functional, things that have been defined by the law of physics or just a rule that has been external to you, but something that you've decided to, there could be parameters, for example, tweaking parameters in the neural networks. Those are free choices. You're doing it, you modifying the parameter, and we'll see some examples later where indeed it's been done. And the work, can be creative and can be copyrightable because indeed there is that connection of free choices there. Are they creative? That's a bit more fuzzy in a sense as a construct. And of course, it can be debated because creativity can be seen in different ways. Maybe it's not so easy. It's a debate. It's like a very casuistic space, but at least we have a notion that specifies more closely what we mean by originality. And these notions have been sort of rehashed in many decisions. I give you some here. Again, BSA and Minister of Culture of the Czech Republic is one that states that indeed it's the work is his own, the author's own intellectual creation. Football Data Co. Is also a very important decision, and it's again rehashes or reassesses the importance of free and creative choices. Again, the Eva Maria Peiner, also very important case, saying the same. So those notions are very much anchored in stone now, at least in Europe. That notion of free and creative choices actually at the center of the possibility of getting a free, copyrightable work. So now that we think about AI, the question will be, is there a human being, we need an author, as you remember, capable of manifesting those free and creative choices in an output, in something that will be produced, maybe intermediated by an algorithm, doesn't really matter, but at the output, is there the manifestation of a free and creative choice there related to that person? If so, there can be a copyright. Simple as that. I could stop the presentation there. I won't, but that's actually the gist of the matter. So in the US, it's actually slightly, of course, a cornucopia of decisions there, but in a very important decision, Feist, it was mentioned that original, as the term is used in copyright, means only that the work was independently created by the author. It's the equivalent of the own intellectual creation, as opposed to copied from other works. At least it has merit of being very, very clear in that decision, and that it possessed at least some minimal degree of creativity. It's not exactly free and creative choices, but it tells us something else, that even a slight amount will suffice. And we see some case law more recent that again emphasize that notion. You don't need to be super creative to get a copyright. As in patents, you don't need to be a genius to get a patent, but you need a modicum of creativity or inventiveness. This is important. And so, but what's important here is that the threshold is not very high, essentially. So that gives room for many creators to produce copyrightable works. So another element of the decision is that they tell us that originality does not signify novelty. A work may be original, even though it closely resembles other works, as long as the similarity is fortuitous. So it's not, you didn't copy it, identically, and not the result as copying, of course. To illustrate, assume that two poets, each ignorant of the other, compose identical poems. Neither work is novel, yet both are original, hence copyrightable. And it's only in the case that they didn't copy each other. So there could be some kind of discussion there. Oh, you've got the same poem as mine. Did you copy me? And you could defend yourself by saying, no, I wasn't aware of your work, so there's absolutely no reason you could claim that I copied you, and essentially that would be the question. But indeed, those two works could be independently copyrightable. Right, human intervention is required. I mentioned it is very important for that very simple relationship between the personality of the author and that notion of originality that defines the copyrightable work. Again, in a decision, a final decision, according to the first sentence of a directive here, only human creation are protected. So that's it. That's it. There's no discussion there. In Europe, at least, the fact that you use any tool in order to produce your work is irrelevant. But at least it should be a human creation. Human should be there in the pipeline. In the US, again, human intervention is required, and again, there is a famous case from the previous years. You see, 2018 was an important year for AI and for animals rights, even, because in that case, Naruto, the monkey, was taking a selfie, and that selfie was, in a sense, sold by the person who owned the camera, and that other parties claimed that there was no copyright because that that person, owning the camera didn't take the picture. So, but and they claim that indeed it should be Naruto, and then it should be that monkey owning the picture. But the US Copyright Office added a bit of a mention in their guidelines also that animals other than humans lack the personality, the right in a sense to own anything, in particular ownership of copyright. So the issue was actually absolutely closed there. You should have a human being, not a robot, not a ghost, not a spirit, which were also cases in the past in the very abundant case law on copyright. There were spirits of Mark Twain, for example, was not claiming copyright, but assumed to have participated in the creation of a work, and other categories of fictional entities, and also, why not now, robots. So no, a robot cannot own a copyright, cannot be the author in law, for the simple reason that the law obliges, as you saw in those two cases, that a human being be present to manifest this modicum of creativity or those free and creative choices. Okay, so that's exactly where we stand. Why do we stand there? Is it the end of the story? Maybe not. I mean, but at the moment, that's where we consider, that's what we consider the function of the copyright. I mentioned very early on that the function of copyright is to incentivize creativity, but by creativity, implicitly, we say creativity by humans, human creativity. Okay, and if this is the function of the copyright regime, then indeed we can't really remove the human from the creativity loop. So it's a matter of logic, it's a matter of politics, also it's a matter of choices. Do we value this kind of creativity, or do we value any kind of creativity? And in that case, we could remove, in a sense, we could lower the threshold of the human presence by, granting rights to other entities, maybe, elephants, it's a case also in the case law, monkeys, or AIs, or neural networks, or robots, okay? At the moment, it's not the case. And there was a resolution by an international association of IP professionals that mentioned a few years back that AI-generated work should be eligible for protection by copyright if there is sufficient human intervention in the creation of the work. AI-generated works should not be protected by copyright without human intervention. Again, that's the idea. And as I mentioned before, in the guidance, the book that is produced by the US Copyright Office, there's also the same mention. If a work's traditional elements of authorship were produced by a machine, the works lacks human authorship and the office will not register it. Okay, that's it. Now, after that sort of very broad presentation of copyright and trying to sort of putting some limits in that perimeter of what is protectable, I'd like to move closer to the topic, to the AI production, because we need to try and see what does it mean for AI-generated work. There's no protection for the choices made by the AI, and this is very anthropomorphic as a statement, so of course I'm putting like air quotes there. But there's also, as you saw from the very early on, almost from Mozart with the game of dices and producing music, that stochasticity, randomness, and a delegation of the choices of the author were very much present early on. I'm not talking about just like pure, Jackson Pollock, for example, or some of the works that you see here, Lionel Murat or John Tigely, where machines or, kind of systems are participating in producing some kind of artifacts, works of art. But it's something in between, something in that level of lack of control that we need to try and think whether indeed there is a room for copyright in the AI-generated art, partially generated art. So the fact that AI is part actually of the creativity landscape is of course debated inside the administration, the copyright offices, and in the same guidance, the copyright registration guidance I was mentioning before, there's already a mention of works containing material generated by artificial intelligence. What does it say? It says that if a user instructs a text generating technology, so it could be ChatGPT, for example, to write a poem about copyright law in the style of William Shakespeare, she can expect the system to generate text that is recognizable as a poem, indeed, it's the case, and mentions copyright and resembles Shakespeare style. That's what we would very, very much expect by playing with Bard or with any kind of large language model like ChatGPT. But the technology will decide the rhythm pattern, the words in each line, and the structure of the text. The technology, not the person who inputs the prompt. When an AI technology determines the expressive elements of its output, the generated material is not the product of human authorship. It's the product, essentially, those choices didn't come from the human being raising the prompt, but from the machine. Okay, that's the claim of that particular passage in the registration guidance. We could discuss that. It's not exactly necessarily always true, and we could always try to push the boundaries. Maybe we'll do it. As a result, that material is not protected by copyright and must be disclaimed as a registration application. So in fact, that would prevent the office that would, based on this guidance, to protect by copyright a work generated automatically, by automatically I put air quotes again, by the system. Why? Because there was no sufficient level of free and creative choices that would be transferred from the prompt to the output. This is a question. Could there be transferable creative choices, free creative choices from the prompt to the output? I would claim that maybe. We need to put this notion to the test. The courts haven't faced, in a sense, that question in earnest so far. But they could, and they will, I'm pretty sure. So that will come. It's not there yet. At the moment, we stand on this sort of assumption that indeed the machine, the ChatGPT, acts as a sort of an opaque filter between the prompt by the user and the output. Again, imagine yourself putting a one-line prompt like this one, write a poem about copyright law in the style of William Shakespeare. Indeed, the level of creativity there is minimal. But imagine that your prompt is very, very, very detailed, that it's dozens of lines, hundreds of lines explaining all the details of that poem, giving it structure, guiding, in fact, the system in ways that some of your choices present in the prompt still be manifested in the output. Then, in that case, you would have a claim. You would have a claim because that connection, that causal relationship between the free choices in the output and their manifestation in the output could still be present. So you would have a case, you would have a claim to defend yourself by saying, okay, look, even though I used ChatGPT or any other equivalent, the way I frame my prompt is so that indeed the consequences are present in the output, not just as an idea, but as forms that were already explicited or implicit, but at least present in the request I made to the system. Of course, okay, this is being very open as a statement, but we'll try to look in some examples maybe and see how to relate to more practical situations. So, what does it mean for AI-generated works? The question will be essentially to try and see where originality can lie, can lurk, can be present. Which solution, if the prompt is an original composition? That's what I told you. Is the prompt the equivalent of Renoir's composition, Renoir and Guinaud? That's a funny story, not funny actually. It's an interesting story because Renoir, the artist, the famous French artist, was very old and had a lot of arthritis, so he couldn't paint anymore. He could barely hold his brushes. So he was also a sculptor, but he couldn't sculpt anymore because he was too old. So he hired, or he actually asked some of his colleagues, another sculptor called Guinaud, to work for him under his guidance. And in that particular case, they co-created, if you will, a work, but essentially Renoir was guiding Guinaud, not an AI at the time, that's a long time ago, but another artist, and pointing to exactly what he had in mind. So the transfer of the prompt to the output through ChatGPT, and the equivalent could be the transfer of the intention of Renoir to the final sculpture, mediated by the action, the physical action of the sculpture Guinaud. And in that case, they were considered both actually co-creator of that final sculpture. In the case of ChatGPT has no legal entity, so it wouldn't be an author, but you, if the prompt is clear enough and precise enough, could indeed, if the logic is followed, claim authorship of that final work. What about the awareness of the final result? That's not a requirement. You don't have to be fully aware, prescient of the output. Imagine again Jackson Pollock, putting some strips of paint on a piece of art, or if you create some kind of music, if you're a famous musician under the influence of drugs, for example, it doesn't mean that your work is not copyrightable because you had drunk too much or used too many mushrooms. I don't know. Well, no, actually, it's not relevant for the matter. So even though you don't control precisely all the elements of this output, the question is not there. You still have a claim for copyright. What about human choices made by the creators of the AI? That's a very interesting question. Because indeed, the creators of the system, even ChatGPT, or ChatGPT maybe not the best example here, but other categories of tools that we look at in a second, could participate in injecting their own free and creative choices. And in that case, it would not prevent you from being creative using that tool, but they may inject sufficient amount of their own free and creative choices to, in a sense, call for joint authorship. They could also be present, that their choices in the output as much as yours. And in that sense, you would have a sort of a joint ownership of the final work. Even works, choices made in the software could participate in that, not to be excluded in principle. We have to look on a case by case and be open to that possibility. It's a bit of a remote possibility, to be honest, but it's not impossible at all. So again, because we don't want to exclude any kind of authorship or creative, in a sense, creative injection on the merit. We don't want to give sort of more merit to you as the user versus the software creator. We have to examine all the possibilities if someone is claiming that authorship, of course. So even more, in the case of machine learning, because we use data, and the input data, as we'll see again through an example, can also have an importance there. So I just want to go back to the reality, a bit technical of AI now, and I won't give you a sort of a very, very precise depiction of what entails the algorithmic pipeline, but very, very, very simply, it goes like that. Also, it's super simple. The reality, I've got other slides that go a bit more deeper in the technical aspect, but I think it's better to leave it aside for the moment. But essentially, you have building blocks like that, speak like a Lego. You have a block that consists of data. Maybe a human would guide the selection of the data, for example, by selecting the category of works that are participating in the data set, or maybe curating it by expunging, removing some noisy ones, for example, or modifying some of the works as well. So this is an element, and we'll see an example indeed, that could participate in a particularly meaningful output. The learning algorithm is the way you train your system to produce your statistical model, the trained neural network that indeed eventually will be capable to output some piece of music in that case. So all of these things, I will try to sort of follow the pipeline, okay? And very, very, very simply ask ourselves, whether there could be originality in each and all of these Lego blocks. Let's take the first one. For example, let's take this one, the data part. If you're selecting the data, but also if you're as you see here in the left-hand side, if you're a creator of the data that's being used in order to train a system, in a sense, what's happening there. And to sort of give you a sort of a practical example, I would go back to a few years back by pointing at the work of David Cope and his production. So David Cope is a composer, he's a well-known actually musician, a composer of his own right, even independently from AI, but very interested early on in neural networks and algorithmically generated music. So he created an entity being a neural network, trained on very, very selective kind of works, like a mix of very interesting works, some very avant-garde works, but also some very oldish Baroque kind of works. So he did a very, very, in a sense, careful selection of the category of objects that were used in order to train his model. And he produced a trained system that learn from the coincidence, from the correlation, from the patterns in all those works, okay? In order to produce Emily Howell, that is, like the claimed author, it appears at least as the author on the records produced by David Cope. If you listen to it, let's see if it works. Right, so I'll stop here, but you see something. Oops, it doesn't stop anymore. All right. Okay, does it look interesting, good? It's up to you. It's very subjective. Could it be done by a human being? For sure. I mean, it could be evocative of Eric Satie or other authors, not claiming to be knowledgeable in the field of music, but you could see that it's something that's fine, actually. And people bought the record thinking it was made by Emily Howell, a woman. But indeed, Emily Howell is a neural network in that particular case. The interesting element is that here, most of the work, I would claim, I don't know all the details, but as far as I understand, at least an essential part of the work is in the curation of the database. It's all the more interesting that it doesn't stop here in ways that makes it even more interesting in terms of that sort of looping mechanism where humans participate almost in real time in augmenting their work. In fact, in that case, David Cope selected his own work. That will be the top. On the left-hand side, he will be like David Cope here, participating, injecting in the training data his own creations, and also re-injecting some of the selected works by Emily Howell. So you see that data used to train the next generation of his neural network is now composed of the works of Buxtehude, Shostakovich, and the Rolling Stones, and the Pixies, and whoever, but also his work, David Cope's, and also the work of the system in the previous iteration, so Emily Howell's works. And that participates in augmenting the data set to produce a next generation. You know, it's very hard to say that there is no free and creative choices there. Would you think? I mean, I think there is indeed a claim for free and creative choice in outputting in those things. And that indeed, those free and creative choices in selecting the content of this training set have an impact, a direct impact on the output. Whether it's being predictable in the very much all details is irrelevant, but that they're manifested, those choices in the output is pretty sure. So in that case, I would say David Cope is the author, not Emily Howell, doesn't have any standing in law, but indeed, he would have a fair claim, David Cope, for that particular copyright on the output. So here, it's a bit misleading because, of course, Emily Howell could be seen as a sort of a proxy for David Cope, but indeed, it's David Cope, the author. What about if we move a bit more on the right here, the learning algorithm? Well, indeed, that's quite interesting. And I would like to quote here a very famous author in the field of copyright law, Jane Ginsberg. And she's saying, actually, why could an AI be more than a tool? What if the AI could be more than a tool? More than a tool, but I need to specify exactly what we mean by that. Here I'm quoting, the idea of a generative machine implies that the machine is more than a tool to which the user expresses her own ideas. Unlike ordinary tools whose output reflect the creative contribution of their user, the output of generative tools may reflect the creative contribution of the tool designers. So in that case, you say this author is giving the possibility that indeed the tools designer may be sort of impacting the output. Is it possible? Is it possible by designing the algorithm, you're in a sense controlling the output? Well, it's not a surprise. We saw that from early on the 60s by the work of Nakeb, for example. Those algorithms. Could we translate that in the world of deep learning? For sure, no problem, easy peasy. I'll give you an example here. It's Mike Tika, and Mike has been one of the sort of the forerunners in the field of deep learning, deep neural network art generated forms by playing with hallucination in deep neural network, creating those objects that were sold well before Edmond de Bellamy at some presented exhibition and sold. And indeed, it's very much there that's happening. It's in the control of the learning algorithm and the parameterization of the neural network, then indeed it will produce the algorithm some certain form. So in a sense, it's exactly going back to the quote by Jane Ginsberg. Here, the creative contribution is not necessarily in the data. That could be very much random data, irrelevant data, random, obtained automatically even from the internet, say, but in the choices made in the hyperparameter of the model by Mike Tika, by the designer of the tool, of the algorithm. In that case, Mike Tika could safely claim to be the author. And there are many examples here. I'm giving you another work here from 2017. Same person. Oh, no, that's Memo Atkins, sorry, but same exhibition, sorry. Same exhibition where the previous work was also shown. And indeed, again, you could say whether you like it or not is irrelevant. There indeed could be some element of choices made at the algorithmic level that are present in the output. And that's the logic, that causality link between free and creative choices and manifestation in the output. So that seems okay, but what if we move a bit further away from that? For example, this example I gave you before with this platform of injecting style in a work. Could it be sufficient to create that free and creative choices that are considered as really the basic threshold for originality, for a work to be copyrighted? Well, I would claim that probably not. Just the fact that you mix an image, a random image on which you don't have a copyright, of course, and it's too easy, but you don't have copyright on that image. The additional choice is selecting a style, I would say that's not sufficient. It may look good. It may look, for example, like this person, but in that case, it may not be sufficient, except if you have a copyright on the original picture of the woman here. And if you just say, please paint it in the style of Klimt, which was the case here. In that case, the fact that you had a filter to that particular image wouldn't deprive the image, the original one, from a copyright. You see, there would be a superposition. It's as if you had a Photoshop filter to your own painting. You created a painting, you had a layer of Photoshop, it's still your painting. Of course, you can still own it as and copyright it. Interestingly, it's not also the end of the story, because I think all those tools of stylistic, game playing offer new ways of being creative. You can sort of mix styles, for example, go from Cubism to Van Gogh or Turner, for example, here, and combine them in funny ways. And in that case, it's just adding layers of parameters on which you can, play, manipulate, choose. So imagine you have a sort of a set of options. There are different categories of authors, Munch and Van Gogh on the left-hand side of the picture, and others on the other. If you have enough of those and mix those specific styles in order, in a sense, to arrive at your intention, your idea, it's as if you were playing with a color palette. The palette is not exactly the same as the blue, the yellow, or other kind of colors you want to play with, but the styles, there are parameters, there are choices you make that can lead you in your own exploration of your own personality. If this is the case, of course, it's ambiguous. I'm not saying it's clear-cut. It's not because you choose 1, 2, 3, or 4 of those parameters that will be sufficient to systematically grant you copyright, but it's a possibility. And I think that's what matters, that possibility of being creative in novel fashions, in novel ways. And I think you see here, that possibility of creating by doing some kind of mashup, remix, combination of styles. And why not? Again, not the simple idea of just creating a style, but playing with style. It's interesting style. And because as you may or may not know, it seems very important in the world of art. Of course, we claim a style as an artist because it's a part of the collection of the works of our works are being united by something that resembles us, like in mathematics, we call a class of equivalents. It forms a group of interrelated entities by what? Our own personality. So it seems very important because it joins us. It joins all our works in sort of like in a unitary fashion, in a cohesive fashion, that sense of style. But interestingly enough, copyright doesn't care about style. So that's an important thing I want to emphasize also tonight, because what copyright measures when it measures infringement, which is actually your capacity as an author to defend yourself, is resemblance with a specific work, not with a collection of your own works. So not with your style as a concept, but with one specific work in your productions. So copyright is only interested in a sort of resemblance between two entities, two specific entities. One work from you, for example, and one potentially infringing work by a potential infringer. Okay, and those two things actually are being explored by the court in ways that they're trying to find similarities. Are they similar enough? In which ways, etc.? And is it fortuitous or not? Those are the questions that are being asked by the court. The court will not try to answer the question: is it something that looks like it could have been done by you? That's totally irrelevant to the court. It's measuring a proximity between two exact existing forms. That's the essential element of the copyright. Access to copyright is the expression in a form. So because of that, we're looking for that connection. So copyright doesn't protect a style, because the style is considered something akin to an idea. An idea, as you remember, that line, that spectrum, are not copyrightable. So what we're seeing happening with this notion of style transfer, the example I was giving you before, is indeed a way to push the boundary and to question the essence of what we want to protect with copyright. Today, it's very easy to copy the style of a famous musician, like imagine Radiohead, for example, a rock band. You could make a Radiohead at the click of a button. And 24/7, you would produce music that would sound maybe like Radiohead, maybe not as good as Radiohead, of course, but that would pass off. That would be like, resembling that stuff. That may not be an issue for copyright, but that would definitely be an issue for competition. So it's not always on the regime, on the platform of copyright that you as an author may be capable of defending yourself. You may need to look a bit elsewhere to say, okay, look, copyright is not in question, but you're in sense, you're employing parasitic behavior, that would be the term we use, so artistic parasitism, to serve, to profit from my work without, putting the work yourself. So you're not adding anything to to your own, by injecting your own creativity. You're just copying my work. Of course, you've used some fancy algorithm to do so, but still, it's not acceptable because you're depriving me from, maybe my economic rights, some kind of survival, if you will, some kind of economic potential of exploiting my works. So that in that way, we see that this notion of style mimicking are showing that maybe copyright is not capable, at the moment at least, to address those issues and protect users. So it's quite important because that's very, very, very common. You see this reproduction of style and the limit of copyright, very sort of simplistic depiction of that, taking all the works, some of the works from Van Gogh, it's a typical example, using an artificial neural network to produce something that looks okay, actually, looks okay. I'm not a judge of that, but looks passable on the right-hand side. And indeed, in a sense, this work is not infringing necessarily on the works of on the left. Well, I'm saying not necessarily. I will come back to that in a second. I will try to be a bit more precise there by looking more precisely at the latest development in machine learning, also to show that we should also be careful there. But it's actually quite interesting because some of the authors have played also with mimicking their own style. I'm giving you one example from Patrick Tressé, again, quite famous artist, who also delegated, for some practical reasons, his style of drawing to a robot. So the hand of the drawer, his hand in a sense is being sort of transposed or as a proxy delegated to the robot that draws maybe like Patrick Tressé. And again, you can interrogate the validity of his claim for copyright or even authorship of that final work. Is it possible? That's a question. It's like self-plagiarism, maybe. Is it acceptable? How much can you go? How much can you copy yourself? Other example, more recent, 2020, So Wing Chung, also a Chinese artist that uses robots also to mimic her own style and produces work in her own style. I mean, there's nobody's suffering from any kind of being deprived from a particular type of work because they're in control. But in that case, is it acceptable? That's also, pushing the boundaries, and we don't know yet. We don't know how far can we go. We could say that indeed she's controlling the system so closely that indeed her free creative choices are, directly manifest in that specific work. But it's some interesting question that, interrogate the boundary of arts. Other questions also are related to the moral rights. Imagine, for example, you are doing some, I would call it fancy and it's a bit pedantic, model transfer, but it's essentially changing the modality, going from the picture to an animation of that picture. Or imagine, a picture to sound, as we can do, like the cross-modal platforms, like, the text-to-images platform, like Stable Diffusion and others, are such kind of tools. You can also do the equivalent with sounds or music now. You can ask the system to produce a music in the style of Radiohead, for example, but a bit more upbeat and with a tonality, a red tonality. Imagine you put a color, something like crazy. But okay, why not? And the system would be able to try at least and infer a kind of music that sort of meets your demands. Okay, is it okay? But I mean, maybe if you're controlling all the elements, but in that case, for example, would you infringe on the moral rights of the author of the first piece? You seem to be doing something else, but can you? The moral rights you remember as two components, at least the one I presented, the attribution right and a right that, in a sense, control the context in which the work will be used. And in that particular sense, I may not be happy with the fact that you put my work to life, for example. I would consider it maybe morally unacceptable. Would I have a claim? Yes, I would, on the basis of the moral right to prevent you from doing certain uses of that particular object. The same here, cross-modality could happen for going from painting to pictures, to more realistic pictures. It was not my intention. I'm talking as Van Gogh now, but it may not have been the intention of Van Gogh to allow this possibility. And in that particular instance, you may be capable of denying or preventing those particular uses. Again, we're pushing the boundaries here because that was totally unexpected, of course, just some years ago. Something else I was not expecting, and again, I'm pushing the boundaries, little by little. I'm eroding the boundaries of copyright or branching it away from the centered, core nature of this notion of copyright, anchoring on this notion of originality and free and creative choice, is to show you that because of the new nature of those tools, we're connecting to other categories of rights. Look at the deepfakes. We all know the deepfakes, and they're actually very important. I mentioned Trump and the Pope before, creating new images that would, in a sense, pass as real. And of course, you can pick your artist now, and soon you will be able to select which actor plays that particular role. You could be actually maybe the main character in that movie of yours if you want. I mean, maybe that's our life, but in a sense, in the movie you see on the screen, you could be your own actor, your own central character. But if you want to replace here one actor by another, Burt Reynolds being now the next James Bond instead of Sean Connery, is it okay? I mean, is it okay even for Sean Connery? Is it the presence of Sean Connery by his demeanor, is part of his personality? And does Sean Connery have a claim to say, no, I'm sorry, I'm part of that object, that presence, where now Burt Reynolds is mixing with my own mimics, in a sense, with my own facial expression, in order to produce something that, in a sense, is different, but where I still have a part to play. What are the roles? What are the rules? What are the regulation that can be invoked to control this, in a sense, these particular uses? Is copyright the right tool? Probably not. We move ahead here a slightly bit because it will be clearer to explain in different categories of works where we have used, for example, voice swapping, not image swapping, as I said before, but voice swapping. And you may have heard about some cases. There are a few in the US, a few in England. There's a Rick Astley, for example, recently brought a similar case for that have been claimed elsewhere in the US, where his voice was interpolated, so it back mixed with other voices in a particular piece of work, and indeed was claiming that it wasn't right. What are the reason he could invoke? What are the kind of rights or he could invoke to prevent those particular uses? Not necessarily copyright, but maybe personality right. And this is indeed, you see that notion of personality right is not something that you would claim copyrightable. You're not copyrightable as a person, but your works are copyrightable. In that case, the voice as an object is not copyrightable, but the use of the voice, can be protected using personality rights, and that can be another channel for regaining control over those new, particular uses, as we see here of deepfakes and voice swapping or image swapping. Again, what we see is that it's not necessarily a lack of copyright of an object, but the fact that the copyright is not thought of originally, obviously, 2 centuries ago, with those possibilities in mind. And because of that, it would be either a possibility could be to change the copyright to accommodate for those uses. That's a possibility, but we have to be very careful by modifying those laws because they're based on a long tradition, and we don't want to fracture this sort of Gothic architecture, very complicated architecture on which that has evolved over now more than a century, by injecting new elements in the law. But we may look elsewhere, personality rights, for example, commercial law, for example, artistic parasitism, as I was mentioning before, to still give some level of control and prevent abuses if we consider those things are abuses. So it's still debate. And of course, there's no right and wrong. It's an open field for exploration. The course are this agora where the debate happens. And we are part of that, in a sense, public, this audience looking at the debate, ongoing debates, as we see with deepfakes and Rick Astley and others discussing where, in a sense, to put the threshold. Okay, so that was an element of style and deep fakes. Another one I want to mention, it's a bit less well known, is working directly on the model. So the model is a bit of an abstraction for many. It's a set of numbers, essentially. It's an architecture. A neural network is a set of, in a sense, nodes, neurons that are mimicking in a very simplified way the way our neurons are behaving, interconnected in a specific way, and each characterized by a set of numbers. So overall, it's not a very complicated machine, but it contains many numbers. And those numbers give you room for modifying them, playing with them, changing at will, in order maybe to modify the behavior of the system. So you could do so, and some artists have done it. Rebecca Fiebrig is one that comes easily to mind. It's a long time ago that she's invested time in exploring how to play with neural networks. So in that case, instead of using a piano or a guitar as an instrument, it's essentially a neural network. And the way she does it is by modifying in real time some parameters of some rather simple neural network, not much simpler than the one we use today, but that shows the possibility the new possibility that are offered by those new tools to produce new artifacts, new objects that were not imagined before. Denying copyright because you have that particular intermediary in the process of creating new works would be foolish. Why? Because it would be denying copyright for just the simple fact of using a computer. And we use computer, I wouldn't say all the time when we create art today, but it's very common. And it would be, of course, sketchy to prevent the use of a computer for the simple fact that you don't master all the details of the internal machinery, the circuits, the CPU, the memories inside of the computer. It doesn't really matter. You control enough of that to be able to inject those free and creative choices in the output, and that's essentially what matters. So no issue there, but still a novelty that you can play with a neural network in order to produce those objects. A final very important point where there's two elements there to be discussed, but I'll be relatively quick here, is the final one. The final element is also a locus of free and creative choices. How? Very simply speaking, there could be a post-production. And in one of those cases from the Colorado competition, the art competition, the person who claimed the prize actually explained that indeed, okay, he used Midjourney for producing this piece of work, but he did a lot of work, a lot of additional work. And he proved it, or I tried to explain that to justify that indeed there was so much work involving in that exercise that it justified, some level of copyright on that. And he was really the author. But here I'm pointing to a friend of Jean-Pierre, François Paché, a very important person also in the field of creative music and AI-generated music, because also we participate in many important works there. But again, in the post-production part of the work, there can be a lot of injection of creative choices that impact the final work. And I would claim that at least that was the case in the work that is Car, where indeed, if you want to listen to it, there's a bit of the Beatles in the background, but there's a lot of additional post-production work by Benoît Carré and François Paché. So if you haven't listened to it,
something new, it turns me on. Good day, sunshine.
right. So you see, it sounds like the Beatles, but it also sounds like the choices of François Pachet and Benoît Carré in post-producing that work quite massively. So a combination there. And of course, we wouldn't deny Benoît Carré's input in that work, and I think we should not. There's also the matter of selection. Selection is also very interesting because in the case of that work by that I was mentioning before, the Edmond de Bellamy, the one that sold for $432,000 at Christie's in 2018, there was a huge amount of selection. I'm not saying actually it's an extreme amount of work, but imagine the possibility that indeed you could, in a sense, inject your personality in finding your way in those millions of options that you're being granted by the system. Maybe it's not that big of an input of originality, but it could. And just because it could, we can't deny it. So we have to ask ourselves, I mean, by we, the courts, the public, that indeed there could be a locus there for copyrightable work. Interestingly enough, it has to do also with the landscape of possibles that are offered by deep learning models. I'm not going to be very technical here, but I just want to give you a sense. The number of parameters in those big models that we create today create a landscape of possibility that is very, very rich and varied, much more so than the rule-based options that we had in the past that relied indeed in stochasticity, in randomness, but in a different setting. To simplify, I'm going to try and explain that with a picture, okay? Let's imagine you have on the left-hand side a very deterministic process, something that would follow a rule. Some of those processes would converge to a single outcome, one option only. So essentially, whatever input you put in, you would have something very, very similar, or actually even identical at the end, the black square that you see at the bottom of that picture. And the system would try to, in a sense, learn how to converge towards that sort of bottom option, the final option, the black option. So you would have no choice here. The system, whichever starting point you would give, even random, would converge to that particular outcome. It's not at all the case in deep learning system where we have a different setting with many, many, many more parameters. And because of the landscape of options, of solutions that are being offered by the deep learning systems, you have many, many different opportunities to discover novel elements in the output from which eventually you could choose from. And because you can choose from this vast landscape of options, maybe there is the possibility also in that selection mechanism to inject some kind of originality. So just being selective also give you maybe room for being creative. Imagine that you play with Midjourney. Maybe you could try and claim that. I'm not sure it would work. To be honest, it would be a bit far-fetched, but you could try. And if you keep the trace of your actions as an element of proof, if you were in a sense to claim your copyright on a particular piece in court, you could say, look at all the choices I've made down the line. I've interrogated the system. I've changed the numbers, the seed, the random seed on my system, and I've explored in very, very specific ways. I've injected my free and creative choices in selecting that particular outcome. Maybe that's enough, in a sense, to create that level of, injection of personality that would deem the work copyrightable. Again, that's novel. We don't know yet, but it leaves options for exploration and thinking ahead. I would pass some slides now and go back to this case of Zarya of the Dawn. I mentioned it at the very beginning as some kind of new discussion, ongoing discussion about copyright law. And it's an interesting case because it's very, very recent, and it was asked to the administrations. So in that particular case, Kristina Kashtanova worked on a novel. She produced a novel, but thought maybe it could be a nice idea now to use the potential of those new generative tools, Midjourney, for example, to essentially produce some images that would accompany the text like in a comic book. And she did so. She did work. She pressed the button. She injected some pieces of her work as a prompt into Midjourney, did some extra work a little bit, and claimed copyright. And in a sense, she presented this to the registration office of the US Copyright Office. It's not an obligation, but if you ask for registration, you can. In the US, it helps if you want to prove that you're the owner, and eventually in court. But in that case, the answer by the administration was actually a bit cold. They said, and you see the examples on the left, they're good looking. They would pass easily as human created. But US Copyright Office only granted a partial copyright to the work. Why? Because it denied the copyright on the images as such. It granted copyright, kept the copyright on the text. Of course, the author is like the example with the picture I gave before. This Christina is still the author of the text. It also granted copyright on the composition. It's copyrightable, composing images together. Maybe you can inject some specific free and creative choices there. And here that's fine, but not in the images. Because the images, in a sense, were not sufficiently manifesting the choices, the specific choices of the author. It's borderline. I'm not saying it's actually the final response on that category of problems, and maybe future cases will depart from this first solution. But at least that's where we stand at the moment. And in that particular instance, even though several prompts were used by the author, the administration considered there was not enough choices made by the author, or at least there was not enough control of the output. Okay, so it's not exactly the final answer, but again, the author Christina said, okay, but I worked, actually I modified, I photoshopped my output, but if you see the before and after Photoshop picture, they're pretty much identical. So for the US Copyright Office, Midjourney's image did not contain a high enough level of human input, the choices, to be protectable by copyright, and that was not enough. A second case I mentioned before by Stephen Thaler is this recent Entrance to Paradise work. So Stephen Thaler is well known for a different case I mentioned before. It's Dabus, is a case of patents where in that particular instance, Stephen Thaler claimed that the creativity machine and Dabus had produced a work, an invention that was brought forward to the patent offices all over the world. And in those cases, also the patent offices said, sorry, a machine cannot be an inventor. If you want to put the name of the machine on the title, you will be denied, in a sense, the title. You need to put a human name on the title. So here again, Stephen Thaler didn't back down, and he said, okay, I'm going to try again with copyright this time. And he sought to register a work for a particular copyright on this piece here, listing the author, the computer system, the algorithm, as the author on the title. And he actually very openly stated actually he had nothing to do with the work. It's just a machine. The copyright should be assigned to originally to the system. And then because I'm the owner, that copyright would naturally be transferred to me because I own this machine. So because of that relationship, he claimed actually the final copyright, but assuming that the original copyright was to be put on the head, if you will, of this creativity machine. But the Copyright Office in first instance denied the application on the grounds that indeed, as was claimed by Stephen Thaler, the work lacked human authorship, because indeed Stephen Thaler said it was not created by me, it was created solely by the machine. And as you saw before, now in the guidelines of the US Copyright Office, it's claimed that there should be human input, human copyright, no, human injection, human authorship, not machine, not robots, not AI. So here there is a direct conflict, and now Stephen Thaler tries to put the boundaries, but he's going to be confronted by the guidelines of the US Copyright Office that says now that, no, it doesn't work like that. We need human authorship. And because of that, basically, even though Stephen Thaler appealed his case, still claiming that the work was autonomously generated by AI and lacked, in that sense, the traditional ownership, but still required, the conclusion by the court that basically was denied. So in those two instances, you see there's sort of a mechanism, I wouldn't say defensive, it's a bit too much, but a way to say push back, to say, okay, look, should be human, there should be human input. And in that case of Stephen Thaler, whether it's human or not, we don't know all the details. I'm pretty sure there's a lot of human, I would consider there's a lot of human input in that background. But if you say so, if you say there is no human input, then don't come and ask us for copyright, because we can't. If you claim there is no human input, we require human input, so basically we say no. In the case of Zarya, it's slightly different, because in that particular instance, it's a bit more balanced. We see that, of course, the work on the Midjourney prompts or output was not deemed sufficient to grant copyright, but in a sense, the organization of the work, the presentation, the display, the architecture of the comic book was actually qualified as copyrightable by the administration. So, of course, not the copyright images, but you could imagine that if the prompted was more complex, if the work was a bit more selective or present in the output, there could have been a claim for copyright. So the story is not closed there at all, but so far we're trying to explore the first stages of the boundary. An important element I wanted to mention, I said at a moment ago, to dig slightly deeper in one of the issues related to machine learning and the fact that those works are inspired by the works of others is a propensity relatively ill-explored at the moment, but it's the subject of research, that those very, very big models we're constructing at the moment, think, for example, ChatGPT, Midjourney, all those massive models, neural networks that rely on large amount of parameters, because they have so many parameters to play with in their brain, I would say that air quotes, many air quotes here, leads them in a sense to try or to actually attempt to memorize the input. So think about it. It's actually the opposite of what we want. In machine learning, what we try to train the system to be capable of is not memorizing at all, it's generalizing. So we enforce generalizability, it's a big word, but we try to make the system capable of generating a new object, generalizing from a few examples. So we would like that ideally, like us, we look at 2 pictures of a giraffe and we are capable of understanding the concept of a giraffe. For a machine, it's not that easy. We need 10,000 images of a giraffe to be able to recognize safely a giraffe in the savannah. But it's not based on memorization, but coincidence, finding the right patterns, the right correlation in those set of images. That's the way machine learning works in principle. But now that we have available so many parameters, in a sense, it's as if we could, I'm sure you were showing you a work from relatively recent by Carlini et al. Those models can work as a memory bank. So we prevent them, we snap them on the head when they do, so we don't want them to memorize, but they do it anyway. They do it anyway because they have so much room for memorizing. And it's not very easy to understand which type of data they do memorize and which don't memorize, but they do memorize a bit. And because they memorize a bit, it has an impact on what? On the reproduction right that is enforceable by copyright. If you're an author, you can prevent others from reproducing. You remember that's one of the patrimonial economic rights that are assigned to the author of a work. So if the machine learning is trained on your work, even if you're not aware of it, because your work is present, for example, on the internet, and if it's being memorized by the system, then it can be reproduced on the output without you knowing. Okay, and that has an impact because it allows you now to claim infringement, because there's been a sort of not a style, a mimicking of your style, which is escapes the boundary of copyright, but a direct reproduction. And again, we see it happening now. Okay, in some relatively pathological cases, if you will, I'm going to show you 2 cases here from Getty Images, where indeed, you see these images of footballers are not exactly the more precise ones, they're slightly deformed, but you see here in those output, the watermark Getty Images present in those images, which means in the sense that there were so many occurrences of Getty Images in the sample, in the data set used by the system, by Lion 5B, for example, the database used to train the systems, that basically it was so much present that it was like captured as a sort of a feature and added to some of the images as if it was something meaningful by the system, see. But because of that, and because you can relate it to the images in the background, in a sense, maybe get images as a claim for infringement and say, okay, look, I'm sorry, you used my images, my reproduction right has been infringed upon. I can say, no, don't do that. So you see, this also something that's being evolved very, very recently, that we see those occurrences, and now we're trying to think collectively as mechanism to prevent the machine learning systems, the big language models or other kinds of narrative models, to memorize unwillingly. I mean, or we force them not to memorize. But it's very complicated. It's not easy to make it work at scale. And again, it's a work in progress. So a final point, because I think I'm getting close to the end now, I just wanted a few minutes, is also an interesting one that sort of turns the question upside down. And you see, I'm going to show you on Reddit something that happens recently. Is it AI or not AI? I'm going to ask you the question. Think for a second about it. Is it AI or not AI? This is produced by an AI system or not by an AI system, this image you see. So there is a Reddit group where you, if you're a graphic artist, you can post your own pictures, okay? And that person, a person, posted this picture on this group. And the reaction was quite fierce. People say, no way, you didn't do that. That looks so much like Midjourney, DALL-E, or Stable Diffusion. I don't believe you. So the artist was banned for that from that Reddit group, because in the sort of the charter of the group, if you will, there was a mention that we don't want AI-generated works, that just human works, not AI-generated works. But the person reacted back, saying, okay, look, you're crazy. I did it. It's mine. And we're in the world, as he mentioned here, in which real artists are being punished because, in a sense, what they do was what they produce as a work looks like as if it could be produced by an AI system, by a generated AI. And you see that's totally the inversion of the discussion we've had so far. Now it's the human being that's being, prevented from accessing that forum of sharing his images with others on the claim that indeed it looks like AI generated. But it's the opposite. It's AI generated work that look like human beings. And indeed in Midjourney, for example, there's a lot of work in curating the database. So we select specific works. And it's why you have a feeling, if you look, I spend a lot of time looking at images produced by Midjourney and others, that is there is a sense of, common traits, similarity between those images. Why? Because of the curation of the dataset, because of the fact that the dataset has been selected to encompass specific category of work, and that is being translated in the output. So I'm going to finish with something now. This is that related to that. It's a bit of an opening. And the question is related to the issue of truth I was referring back at the beginning with these deepfakes and, Trump, the Pope, all the images we see that. We don't know exactly what's what anymore. We don't know what's been created by a human being. We don't know what's been created by AI. The boundary are very fuzzy between personality rights and AI-generated objects, between the style and the copyrightable entity. And that seems to be, very open and very broad questions indeed. Maybe we need some kind of guidance in terms of labels, some kind of responsibility also as creators to say, okay, I want to adhere to a set of principles and I want to be able to use AI, but still leave room from human creation. Maybe we need to invent some kind of label assisted by AI, made by AI, not using AI, to oppose to our creations, and maybe just to open a discussion about new kind of labels for artworks. So this is very, very open. This is always, I don't claim any final say on what's going to happen next, but I think it gives us a lot of room for discussion, or at least food for thought. And I think on that note, I will close that presentation tonight. And of course, if you have any questions, very happy to try and answer those. Thank you so much for your attention.
Thanks a lot, Jean-Marc, and I'm really impressed. I was expecting that your talk would be very challenging and very interesting, but I'm even more than I thought. So really, congratulations. And there are several colleagues and that are connected, and some of them started to prompt some comments. So I will convey to you. But at first, really applause for the great talk and fascinating. I have some comments and questions, but first I will let the audience. And so the first comment is from Mila de Oliveira. Actually, she was one of my students. And she's still working on this AI generation and of art, and there's music. So she wrote, she's from Brazil. Recently, I noticed that sometimes I see artists painting on social networks, and my immediate thought, unconsciously, looks like AI art, even though it was their art that fed the models. And she adds, I have read that Japan allowed the use of all artwork available to train models without the requirement of copyrights.
It's interesting. So I don't have time to go in all the all the details of the copyright framework at the moment. One is access to data. So of course, it's a very, very business kind of incentive to try and motivate the troops, the businesses in Europe and elsewhere to develop AI models. It's very competitive. The one who owns ChatGPT, OpenAI, has a lot of power today, like Bard and Google and other equivalents elsewhere. We would like to have the same in other jurisdictions, in Europe, in Japan, in Singapore. How do we do it? We try to open the boundaries to allow, in a sense, access to data so that we can train models. So by creating what we would call in copyright exceptions to what? Exceptions to the rights of the rights holders, of the copyrights holders. We create exceptions and we say, okay, look, for example, if you want to do research, we won't be able to prevent nobody will be able to prevent you, even the copyrights holder won't be able to prevent you to train your system for text and data mining based on their work. Why? Because you're doing research and you're doing text and data mining, and we consider as a collective that very important for society. Okay, fine, that's fine. But we add another clause and we say, okay, look, if you're doing for commercial purposes in Europe, you can do it, provided the authors didn't opt out from that exception. So a bit convoluted, but in a sense, we leave room for you to be able to exploit copyrightable work without asking, but we ask the authors to manifest their intention explicitly by opting out. And opting out means what? Being putting a label, okay, in digital form on the website, for example, by saying no robot or no AI training, something like that, okay? It's complicated because you don't have full control of what's happening on the web. So if you copy your image and it's been copied 100 times, like it's happening all the time, basically, well, that's it. You've lost control on that particular opting out option. That's in Europe. In Japan, they go much further. They say, look, it's open game. Actually, you can do whatever you want. If you can, even for commercial purpose, use copyrighted work for text and data mining. Not necessarily for reproducing the same work. That's preventable by law under copyright regime. That's fine. But for using that work to train a model that will do something that's different from your work, that you can. And it's of course at the nexus of the issues we've talked about. The issue of style, for example, is very much there. Of course, if you make the mistake of training your system by overtraining it, that issue of memorization, for example, then you take a risk of reproducing the work of the author. And in that case, it's wrong. Okay, then there'll be a sanction. But if you use it for producing things that look alike or that just like exploit in a sense your original work as an author, in Japan, that's possible. In Singapore, that's a bit in between. And in Europe, we have some kind of those Article 3 and 4 of the Text and Data Mining, the Digital Single Market Directive. And in the US, you have fair use and other kind of ways of handling that situation. But we are exploring collectively at the global scale different options, which leaves openings in sense of forum shopping. It's forum shopping in the sense like picking your law and going, where it hurts less or it's more profitable for you. Which people will do. People will train their system in Japan and try to, for example, protect it in Israel and deploy it in the US. And you see, you will have different categories of law applicable for different phases of the development of your AI pipeline, because it's a bit like a Lego. Sort of, it's not that simple. Of course, I'm simplifying massively, but at a certain level, it's a bit of that. You could say, okay, I'm going to do most of my training in a jurisdiction where it's very permissive in terms of accessing and handling copyrightable works. I'm going to port that model, for example, in a place where it's very easy to protect it, my trained model, very difficult in Europe, doesn't really work, but possible in different jurisdictions. And then when I protect it based on that law, it's defined by the law, the local law, I'm going to use it elsewhere for different purposes. No, that's what's happening at the moment. But you're very right. It's a very, very important topic. And I'm sorry, the answer was a bit longish, but it's a good one.
No, it was not longish. It was very clear, like your talk. And because it's a deep question. Well, thank you, Mila. Molto obrigada for the nice comment. And she added actually great presentation. So
thank you so much.
Like me. So for now, I don't see. Yes, you deserve a drink. Me too. I actually okay. Until there's no more comment or question, please feel free to comment and ask. I want to go back to your what you said at the end. This kind of inversion. It's very interesting that somehow. At first, when you see, for instance, the case of the Edmond de Bellamy's painting, it was sold for 300,000 because of the hype, because it was said to be the first painting painted by AI. But right now, you showed exactly the turning point that now it will be. It's getting less hype because more and more people are doing it. And second, now exactly you need to prove if you claim that it's AI made or with AI as a tool, you need, as you explained it very well, you need to prove that there is some creative choices managed by the human being. Sufficiently enough complex, enough rich to make you claim. So it's probably you showed the starting of the turning point, and your example of the artist who had to defend himself, saying no, I made it with my own hands. And of course, if he's using like pencils and inks, he could. I assume that the court will follow him. If he can show the hand. I mean, physically made. Before scanning it. But if he's working with only with digital tools, that's a question. How can you prove that actually it was? You would have to do some kind of reverse engineering to try to prove that it was not AI made. So it's a very interesting point that I found you made. So it's not really a question, it's more of a comment. So maybe, I don't know what you can...
If I can bounce on that, I agree with you. I think it's fascinating also for what we consider us as, what's that, that landscape of machine-generated artifact, or where machines contributed significantly to the free and creative choices, if you will, or reduce the scope for free and creative choices, and what we consider, art. The question from, I think it was Mila also mentioned that she shows on social network that look like they could be generated by AI, and indeed those AI systems have been trained on human beings. So there's a bit of a closing of that loop, and the issue of proof that you refer to here is very important. How am I proving my case? How am I proving that I'm a human being? You don't know. I could be like a figment of your imagination and we live in a simulation. Why no? I can't prove that. Or I could be just an avatar on the metaverse and, you know, maybe Zuckerberg can make us look like realistic like that, and that would be the new reality. How do we prove we're human? How do we prove we do, you know, anything? In law, proving, the notion of proof is being really deeply interrogated by those new tools. I don't make any prediction. I'm always wrong when I predict anything, but I can imagine that it could be a business.
Which means it's a good prediction, because we just need to negate your predictions to get the right one.
Yeah, exactly.
Good predictor.
Liar's paradox, no. But okay, like an attempt at a prediction would be that there would be a business to make a kind of a system to, in a sense, you know, archive the steps, the decision you make to produce pretty much anything now. And particularly in the field of arts, you know, if you archive all the steps, all the choices you made down the line, maybe some would be sufficient to be brought forward to a court and show, okay, look what I did. What do you say? Is it okay for you? Do you think that's enough real creative choices? And the judge would try to weigh, you know, and put that in the balance and say, okay, in that case, yes, that's fine. Or in the other case, like we saw with Zarya of the Dawn, not enough. And, you know, more and more we would navigate that parametric space of choices and try to, it's a very qualitative space, of course, it's complicated, multidimensional, but we try to find a way there and say, okay, look, that seems to be the right threshold. But we need the proofs, and as Jean-Pierre said, we don't have them at the moment. We don't archive every snapshot on our computer each time we input some, you know, so we click on a button. We don't do that. We don't have the tools for that. But I'm suspecting they will happen. They will happen because some people will need them in order to manifest their rights. And they don't want to be deprived. We don't want to deprive people, creators, from their own right. At the end of the day, we have to go back to the function of the law. We have to go back to the very, very beginning. What's the function of this right? Why do we invent rights? Is it for the pleasure of satisfying lawyers and, you know, allowing them to claim I've created a law when they're old in their deathbed? No, actually, it's because it serves the people. It serves us and it serves society as a collective. If we consider that human creativity is important, we have to try and frame actually the law so that it serves that purpose, okay? Is it working at the moment? I would claim that relatively yes, I would say still surviving. Will it need to evolve? Probably. Because of all those intersections I was mentioning before, you know, the personality rights, they're very much impacted now. And of course, it's tempting when you're a kid, when anybody can do it. It's not complicated at all to use those tools anyway. You import a library, you go on GitHub, you copy your code, and that's it. It's pretty much, no, that's it. That's what Edmond de Bellamy is, how it was created by the group of obvious. They went on GitHub, there was DCGAN, it was like a generative adversarial network architecture, just copied it, and there was Art DCGAN and dumped some data and produced their work, sold it for $432,000, good work. And now they're famous. So, but the function of the law is very important. And now it's been interrogated, and we need to find the right connection, the right balance to make it work the way it should. So I think it requires not the work of lawyers only, but the work of Jean-Pierre and the people interested in thinking deeply about the connection between technology and creativity. And beyond that, I think it involves everybody, because as I mentioned before, copyright concerns everybody. You don't need to be Rembrandt. You don't need to be Mozart. Everybody is a creator. And because of that, we're all concerned by those questions, because eventually we will use AI, like we use ChatGPT now I use it for coding, for example. It's my best friend. It's my best friend coder, very patient. I can ask a stupid question, the system will answer. It will help me quite a lot. So it's becoming part of the toolkit I'm using, not every day, but almost every day. And it's going to be part of like our common daily routine, like the computer, like the calculator used to be, etc., etc. So we have to accommodate those new objects and think carefully about the function of the law. And if the function of the law is to incentivize creativity, we have to navigate that new technological landscape so that this this purpose is served well for the common good.
I cannot agree more, and the objective of mounting this cycle of seminar within the chair, Heitor Villa-Lobos chair about AI, arts, and creativity is exactly to try to raise the awareness about these questions, and not for the people to be either too much naive and too much hoping for everything will be nice, or on the other hand, being just passive and pessimistic and saying, well, anyway, we are. I mean, this is over. Machine took over, so it's not like that. But we are. It's really, as you said, it's very disruptive. So we need to learn the usage. Right? Like a baby learns to ride a bicycle by riding the bicycle. It's something you said that I have to. An artist will have to prove that it's not AI made, and it made me remember one of the great visionary researchers in AI in France, Jean-Louis Laurière. He said sometimes, prove me that you are not a machine, inverting exactly the usual, AI will never or will never be as intelligent as human beings. Actually, we have to prove that we are not AI, that we are, and it's difficult because it's also is intelligent just boiling down to computation, so on a different machinery substrate. But anyway, it's another
it's a very interesting. It's a reversal of the Turing test, so it's very
yeah. Of course. There's still no more. So I have something and making the connection. Something you said I found fascinating, that the idea, the hypothesis that two poets could create in a completely independent manner the same little poem, and both of them could claim that they copyright as long as it was exactly, they could prove that it was independent. And it reminds me of some that a while ago in history, Unix became, very, very, very famous, and it was actually from Bell Labs. So it was not Linux. I mean, it was copyrighted, and it was trademark. Well, I don't know exactly. The software is copyright. There is no patent. Anyway, but I remember that at some point, IBM hired programmers, software programmers, to rewrite actually Unix equivalent, but they had to write down some text claiming, that they never had any look at Unix original code. So it's I guess this was exactly the same, because software is copyright based, like for art. So it was exactly to protect IBM for a possible infringement action, saying that they had a look at original code, and they were copying. So they had to. So it's just reminding me of this. So the same old story in a way.
Exactly, that's a good example. I didn't know this one, so I'm
it's
my classes. I think it's a good one.
It's an interesting one. Still no more comments, so I continue. But please, for the audience, feel free. Don't be shy. Take your chance. And I was. One more comment is that actually, it's very, very complex and very subtle and very also subjective. I mean, for the courts, for the judges, and for the lawyers to exactly as you showed to where is the threshold between this creative spark, this creative, also in regard to the combinatorial of parameters, etc. So one of my comment and actually also question is that it's going and it's already difficult for the judge and to catch up to keep, because they need to get more and more, not becoming experts, technical expert, but at least to understand the machinery behind these new tools to be able exactly to judge this kind of the level, this threshold of creative intervention by human. So it's how do you see this? Because it's there will be training and there will be
absolutely. I mean, that's what we're doing. I mean, we created 5 years ago the first training for judges and for lawyers on AI and IP, and it's a success now. It's a master's program, and we're getting a lot of demand all over the world. It's in English and it's for everybody, so it's in distance learning. But we're trying to serve that community so that essentially bridge that gap between technologists, people who master the technology, like Jean-Pierre and others, and the lawyers who understand the law but don't always understand carefully the technology. So they're always anthropomorphizing, or they're fantasizing about, the fear as that's all, very much stretched spectrum of overemphasizing the potential and being having some kind of disappointment, so winters and summers of AI, and the other one that are very, very anti, or not Luddite, but just careful and or sometimes reluctant in learning. So we have very broad spectrum, and so personally, I've been engaged in that part. That's what the reason I came back to the university framework is actually to try very modestly to create that bridge and to say, okay, look, if you're a technologist, be aware about the law because it matters. It gives you context. It gives you a sort of a fancy word, teleological. So finality. Think about the finality. What are you doing this technology for? And think about the consequences early on when you produce a model, like, the question of biases, for example, social biases, racial biases, and so forth. It's a political question. Technology is very much political because the uses can be, all over the place. It's a general purpose technology, AI. You can use it for detecting cancer or piloting a drone that will drop a bomb somewhere. You can do it for many, many different things. Technologies are, not necessarily good or bad. It's the use we make of those technologies. So it means, like, for technologies, it's very, very important to see that there are consequences sometimes to very, very technical choices they make early on, potentially, not always. And then the reverse side is for lawyers to not be afraid of technology, because if you don't understand technology a little bit, it's very hard to judge, as Jean-Pierre mentioned before. So we're trying to bring together those two worlds, and it sort of works, I think. So it's a joke apart, but actually, it's in the courses we have about 30 hours of coding for the lawyers. So they try to be introduced to Python, to some of the simple libraries, and essentially also 30 hours of algorithmics. And after that amount of time, we create together meaningful works. Meaningful generative engines that do things that are not exactly trivial. So even I did that with judges in the past years, for example. We do things, and judges, what I mean by old judges who are 60 years old, have never coded in their life. So at the beginning, they're like children. They're very completely afraid of touching the computer and thinking that they are capable of producing anything meaningful. But very quickly, they understand it's not that complicated. And our role as technologists is to be honest and show that it's not that complicated indeed. Of course, if you want to be the best in the world, it's always complicated. But to reach that level where you're empowered and you understand the concept, that's possible. And I think that's very, very important that we teach the current generation, not just the younger generation, but also the current adult generation, to understand the nature of those objects, so that they don't become the next Yoshua Benjo or whatever, the best in the world. Of course, that's the issue. But they're not afraid of the technology, and they can ask the right question. They can be critical about it, analytical a little bit about it, and conscious about the risks as well. So that's education is really super important.
Yeah, again, I cannot agree anymore. And that's a great. I didn't know about this thought, and I think it's very, very, very important and very, very necessary. So it's great. One more comment about this because at some point you showed the from Ginsburg, Ginsburg. I was I had a little shock. I thought, wow, he wants to open the Pandora box, saying that AI won't be just anymore of just a tool, because in a way, keeping the AI and whatever as a tool makes us safe in the meaning that we can still apply the standard business as usual. If not, then could get out of hand. And as you told, they're usually in the repertoire of you use what is the personality rights. Actually, apply, I think that's a good idea. Use the repertoire of rights, of rules existing, and adapt them to the current context, rather than adding new rules and the risk of as you said yourself, just everything falls down, and at least getting some like the French code, is known to be too complex because there are so many laws that they contradict themselves, and it's getting everybody's supposed, every citizen is supposed to know the law, but when it's getting too big and too inflated, it's getting out of hand. So it's another challenge, but I think it's a good direction, and not starting to break the existing model, as you said, which is grounded on a lot of as you said, the examples you showed, the photography and lithography. So in a way, it's business as usual. This kind of problems occurred already. The painters, were paid for painting your portrait, my portrait, saying, "Whoa, with photography will be will be without employment," and they are not. So it's fortunately there are many reasons to believe that it won't get into and maybe I stop here and make you if you want to comment on
I agree. That's also one of the claims I'm making. I'm not claiming that the future won't push us in directions we're not anticipating. That, of course, we cannot know, but for the moment, I see it twofold. There's a toolkit already available that we should, think about when we're trying to preserve the right of, for example, the creators. Okay, and that's the goal. So creating new laws is always tempting, as I mentioned before, and I put that with a sort of a smirk a bit almost, because I know that it's tempting to put your name on a new, exactly, physics, for example, but a law of law also, and it feels maybe something like a motivating endeavor for the jurists and the lawyers and etc. But it's very risky as well, because it's not just a legal system where we have 78 codes and hundreds of thousands of laws, and it's a nightmare. Even if you don't go there, it's complicated. It's complicated because why? There are many, many different actors in society, stakeholders, we call them, but that need to converge at one point, hopefully in a public democratic debate, to agree on a concept, and that becomes a law. And the law, they change all the time, they're being sort of tweaked and modified, but creating a new branch, for example, a new personality right for a robot, that was a claim in 2015, 2017. There was a bit of a debate in Europe about injecting that notion, and was discarded immediately by saying, look, don't go there. Don't go there because it's not even risky. It's first, at the time, it's meaningless. And then you're going to disrupt everything. Because if you create a new entity, we have, several entities. We have natural persons like you and me. We have legal persons like a company, but it's still representing human beings. So that's like a proxy for human beings that are, inside a company. Creating a totally different branch of a legal person, for example, for an AI system, may feel interesting because we perceive those cognitive prowesses, those mimicking properties of systems, because they've been trained to mimic, in a sense, also. And we can, in a sense, consider that there is a level of consciousness even, or intentionality behind it. Impossible to prove, as far as I know. I don't know how to prove that. Turing test is very complicated, and it's not fully satisfying, even conceptually, to address these issues. But it's not sufficient to say the ChatGPT can write like probably better French than me, I guess, with less mistakes for sure. Is it enough to grant a personality right to ChatGPT? Absolutely not, because of course the consequences, and we have to anticipate all those consequences earlier. So I agree with Jean-Pierre. I think it's very important to try and be, careful first, but also consider all the sort of the set of laws available at the moment, and be imaginative at the same time by trying to connecting them to the issue in order to serve again that function of the law. So again, going back to the function, what do we want to do with the law? The law is just a tool at the end. It's nothing else. It's not very complicated conceptually. For those of you who are manipulating other tools, this is just a tool of a different kind, not super complicated. The language may be complicated, but the ideas are not. And we have to be also very modest and simple at the end. The goals at the end are usually quite part of the common sense, if you will. And here the goal is promoting creativity. For example, for the patents, sometimes easily to conceive for patents, because we want a drug, like a molecule to cure pathologies like cancer, for example. And we want to incentivize people to maybe invest their time, their energy, sometimes their money in research and development to go in this direction. The law only serves that that incentive. So the rest is just details. If the law doesn't work, we change it, but what remains is the core objective. So again, if we can play with all the set of available tools to promote creativity in human beings, I think that's at the moment important. If we consider that promoting creativity by machines becomes equally important, then we may need to think about other legal systems, but not creating new personality, right? It could be like we sometimes invent sui generis rights, or specific rights for databases. For example, we did it in Europe. It didn't really work, by the way, but we did it anyway. And we try to say, okay, we want to incentivize people to build together corpora of data, to share them with others. So because of that, we consider it's important. It doesn't fit very well in the existing rights. We're going to create a sui generis right, which is essentially a producer's right. So it's going to incentivize people to put money to produce the database and reward them by granting them an exclusive right on that object. People try, that's in limited cases, it's safe, I would say. It's not, don't take much risks, but you have to be very careful about it, trying to anticipate also the ramification of those rules.
There's a question from Carlos Arana, who's from Berkeley School of Music and also University of Buenos Aires. So hello, I just joined, he's also a musician and computer science. I just joined the chat. My question is, can we ask providers of generative AI creation applications to report the copyrighted content they used for training the models used in the app, in the application?
It's a very good question. Can you ask them? Well, depending on jurisdiction, there are certain element of requirements of responsibility of the platforms, in a sense. The moment they're ill qualified they're not exactly platforms like, for example, an editor is a platform, like Facebook, maybe a platform, maybe Google with the news is a platform, etc. There are different categories of entities for which different categories of rights apply, and usually very specifically addressing some kind of modality. For example, news, bringing news to the public, and you're gathering some news, you're sharing them to the broader audience. For example, the Google News platform, and that's addressed by a specific type of right. If you think, for example, Stable Diffusion, Midjourney, and etc. We have an idea more or less about the Lion 5B, so the data set that's been used to produce the images, and at least if we trust it, we have access to that database, okay? But for OpenAI, ChatGPT, it's a trade secret. So here, it's a conflict of rights, and it's even deeper than that. So Carlos, it's a very deep question you're asking, because actually it's part of, our mandate as legislators, as lawyers, to try and think deeply about the conjunction of laws. And I'm going to highlight two ones. So there are two fundamental rights at play here. The rights, I would say even two or three, but okay, at least two. The rights of the creators to control their works, and actually it's a fundamental right to express yourself fundamentally. So it would branch and connect to this sort of set of fundamental rights, the freedom of expression, if you would. The second one is property right, and it connects also to you as an author, but not exactly on the moral side, but more on the property side. But it also connects to the trade secret side of things. So here you have a right of property or right of making business. It's also a fundamental right in some ways, and the right of freedom of expression or controlling your creations. Which one matters most for society? I can tell you, surprisingly, there's no clear ordering of those rights. You could sense intuitively that freedom of expression should prevail. Well, no, it doesn't. In the courts, it depends. You have all cases of matter. Oftentimes, the courts will be very, very careful at preserving the livelihood of people that are working for certain companies that depend on trade secrecy. Imagine you're raising against, I didn't go that far in my presentation, but I've got a few cases against OpenAI at the moment, ChatGPT, by people claiming that rights have been infringed upon their copyright. It could be also other kind of rights, like, for example, privacy rights could work as well. And that could be a way to try and open that black box, the data set or the model, and try to connect it to what's happening inside, and eventually to your data or your work. But if you do that, and you go to court, the judge will try to balance those rights. Your right as an individual to know what's happening, and you're curious, is it enough? Or you feel your rights have been infringed upon, do you have a proof? And the risk of opening the black box, even in a closed setting. So opening the black box is revealing to the wider audience, and by wider, I don't mean the whole public, but a wider audience, the content of that data set. Because if it's claimed as a trade secret by OpenAI, by others, and it could be considered as having commercial value. There's a definition in different kind of text of what is a trade secret. Secret is an information secret that has commercial value due to the secret, and that you keep secret, actively by reasonable means. Reasonable means could be legal means or technical means. So that is the perimeter of a trade secret. If OpenAI says, okay, look, my business is depending on not sharing that trade secret, keeping it secret, essentially, I don't want to share it. And the judge will say, okay, I understand, you've got a point, maybe. But if your case as an author is so important that indeed the balance goes in your direction, the judge may opt for opening the black box, opening the trade secret. In other cases, as is often the case, they will not. They will say, look, fair enough, but sorry, the fundamental rights or the right goes in the opposite direction. So do we have a mechanism to reveal, in a sense, the content of the training set? Is my data used to train OpenAI system, or Bard, for example, for that matter? Doesn't have to go OpenAI or against OpenAI all the time. It can be Google also. It's another target. But at the moment, you have means, recourses for action, Are they effective? Not really, not systematically, at least not 100%. It depends on the case. So it's still something we need to ponder, because of course we don't want to be too crazy. We imagine that everybody's anxious about that, and then hundreds and thousands of cases against a company because we fear it's misusing some data. It can be very costly and it can disrupt their businesses, and we have to take that into consideration. If there are real doubts and if there are good reasons, yes, then we should. But at the moment, it's still very early on. I mean, still, I would say, still the Far West. We're really exploring all options, but it's a super good question. I'm thinking also we need to incentivize what we call, I don't know if you mentioned platform at the beginning, or just like those operators, if you will, or those the people who generate those tools, to think ahead very early on, and even think in terms of technical solutions. So how to make that connection between the rights. You know, for example, you as a creator, you put a license on your work and you say, okay, I want to share my work, but I don't want it to be used for commercial purposes. I want it not to be used for training drones that will drop bomb in Syria. I don't want to be used for certain I don't know, disrupt indigenous population in Brazil or somewhere. I don't know. You put your framework, what you consider is fair and responsible. And you frame it as a license. It's a kind of contract on your work. And then you force, in a sense, the operators to abide to the rules you've decided as a creator. You can do that. I mean, there are existing tools, and now people are developing more and more of those responsible AI licenses that are capable of more precisely, with more finer granularity, depicting your intention, or giving you means, to play with, in a sense, to express what you consider okay and what you don't want people to do with your work. And because it's your work, you have a control, you have an exclusive right. You can, frame it inside a layer of a license, an additional layer, and say, okay, I want people to play with it, maybe, but under certain conditions only, and not for certain issues. For example, you could say, I can imagine, I'm just inventing a clause in a license then, but you could say, okay, you as an operator, you can play with my data, but you have to tell me. Okay, those rights exist. It's the opt-out I was mentioning before. You have to request permission before doing it. But maybe you could say, not you have to ask me, but you have to tell me each time my work has been used to produce another work, with a certain amount of participation in that work. It would make it very complicated for operators. Maybe they would say, okay, so we don't know how to do that, so we prefer not to use your work. But eventually, maybe some operators could do it. Maybe they could invent new technologies that are able to trace the input and the output and measure the contribution of your work in the output, and say, okay, look, this work has been created with 5% of your contribution, and that could be maybe useful to you. So you see, it's ongoing. At the moment, we don't have a sort of a perfect magic wand to open the data set because they're protected by trade secrecy. But I think we shouldn't stop there. I think it's okay. I'm not, shutting down opposing necessarily the use of trade secrecy. I'm not for it necessarily, but I understand it, and depending on the phase of your development as a business, can be very useful. But we should strive for transparency and, in a sense, try to instill responsibility on the people who develop the platform as much as we can, by allowing them to think about the licensing terms, or the fact that you can add some layers of control over your work. But thanks Carlos for the question. It's really very, very good.
Yeah. Thanks, Carlos. Yeah, it's I'm just it's getting late, so maybe there's no more. Just quick comments. I think that idea of licensing is working on this condition is the one. And I'm just thinking about, of course, there's the Creative Commons but also for software, because again, I'm from computer science, and this license it's interesting because when this, open source movement started, many companies say, "Wow, no, you will be, you won't earn any more money. You will be, because you won't." But actually, no, the service. So I hope the same movement will happen. That is that exactly. There's also the open data for the parameters. For instance, the Hugging Faces. There are various platforms who offer exactly the parameters, but not only parameters after the training, but also of the model, but also, of course, the data. And it's also like in research for reproducibility for the scientific. All the process we need to be able to replicate, refute, and so it's we are in the turmoil moment, but I hope exactly this good practice coming from even before computer existed. They will prevail, and actually we could build up on this. And for that we need to understand, we need to train, we need to teach, and that's exactly what we are doing. I will stop there on this. I will see. No, there's no more. But wow, this was great, Jean-Marc.
Thanks, Jean-Pierre. It's a pleasure. It's a pleasure to be also discussing with you and the group, and I really appreciate what you're doing. Actually, I just had a quick look at the series of talks. They're all very, very inspiring. So bravo for that. That's really great work.
Thanks a lot. Thanks a lot. And so we have to meet again also. Lots of things to discuss. But yeah, again, thanks a lot. Muito obrigado, Jean-Marc, por la mente que we just got through the schedule, but because it's intense and very, very interesting, and of course you can replay at any time. Carlos said, "Fantastic debate." Thanks. No, I'm very happy, and there will be another seminar next week from Philippe Pasquier from Simon Fraser University in Canada, with lots of experiments about AI and new techniques for not just for music, but for lots of different arts. So lots of interesting things to come. So please stay tuned, as we say. And again, Jean-Marc, thanks a lot, and à bientôt. And so, André, I think you can shut. Mila also said thank you, and she said a great. So lots of great comments.